start. It is next submitted by learned counsel for the petitioner that his father was posted as assistant sub-inspector at 63 Battalion CRPF and he died on 18/5/2016 in Harness, leaving behind his widow wife and petitioner himself as his legal heirs. Petitioner's father was the only bread earner of the family and consequently the petitioner made an application for being appointed under the dying in harness rules applicable to the said organization for the posts which have been earmarked for the same. The petitioner was asked to appear for physical test on 13/5/2019 at Noida and which he could not clear and consequently was found unfit for being appointed on the post of constable. Consequently, case of the petitioner was also considered on the post of Havaldar Ministerial or Assistant Sub-Inspector, but his candidature was again rejected on the ground that he was over age and also because of his marital status. Subsequently, the petitioner was also considered to be appointed on the post of driver, but the same could not be considered as the petitioner has not submitted any driving license, and while rejecting the application of the petitioner, it has been stated that they have considered the application for appointment, but due to the aforesaid reasons, compassionate appointment cannot be given to the petitioner. It has been submitted by learned counsel for the petitioner that he had made the application for compassionate appointment in the year 2016 and consequently his age as in 2016 should have been considered while considering him for appointment and therefore his application should not have been rejected on the ground of over age. Heard learned counsel for the parties and perused the record. It has been noticed that the age of the petitioner on the date of consideration of his application for compassionate appointment would be a relevant consideration. For compassionate appointment, there are several applications, and whenever vacancy is offered to a candidate, his qualifications and eligibility has to be considered according to the post against which he/she is being considered, and therefore the age as on the date on which the application is considered would be the relevant date and not when the application is made. In this connection, reference may be made to the observation of Honorable Supreme Court in the case of the State of Uttar Pradesh and others versus Premlata in Civil Appeal number 6003 of 2021 as under. While considering the issue involved in the present appeal, the law laid down by this court on compassionate ground on the death of the deceased employee are required to be referred to and considered. That the compassionate appointment is an exception to the general rule that no aspirant has a right to compassionate appointment. The appointment to any public post in the service of the state has to be made on the basis of the principle in accordance with Articles 14 and 16 of the Constitution of India. Appointment on compassionate ground can be made only on fulfilling the norms laid down by the state's policy and or satisfaction of the eligibility criteria as per the policy. The norms prevailing on the date of the consideration of the application should be the basis for consideration of claim for compassionate appointment. As per the law laid down by this court in Catena of decisions on the appointment on compassionate ground for all the government vacancies, equal opportunity should be provided to all aspirants as mandated under Article 14 and 16 of the Constitution. However, appointment on compassionate ground offered to a dependent of a deceased employee is an exception to the said norms. The compassionate ground is a concession and not a right. In the case of State of Himachal Pradesh and another versus Shashi Kumar reported in 2019 3 SCC 653, this court had an occasion to consider the object and purpose of appointment on compassionate ground and considered decision of this court in case of Govind Prakash Verma versus LIC reported in 2005 10 SCC 289 in para 21 and 26. It is observed and held as under. As a rule, appointments in the public services should be made strictly on the basis of open invitation of applications and merit. No other mode of appointment nor any other consideration is permissible. Neither the governments nor the public authorities are at liberty to follow any other procedure or relax the qualifications laid down by the rules for the post. However, to this general rule, which is to be followed strictly in every case, there are some exceptions carved out in the interests of justice and to meet certain contingencies. One such exception is in favor of the dependents of an employee dying in harness and leaving his family in penury and without any means of livelihood. In such cases, out of pure humanitarian consideration, taking into consideration the fact that unless some source of livelihood is provided, the family would not be able to make both ends meet, a provision is made in the rules to provide gainful employment to one of the dependents of the deceased who may be eligible for such employment. The whole object of granting compassionate employment is thus to enable the family to tide over the sudden crisis. The object is not to give a member of such family a post, much less a post for post held by the deceased. What is further, mere death of an employee in harness does not entitle his family to such source of livelihood. The government or the public authority concerned has to examine the financial condition of the family of the deceased, and it is only if it is satisfied that but for the provision of employment the family will not be able to meet the crisis that a job is to be offered to the eligible member of the family.